both national issues and issues concerning the PFF. Time to introduce them. Today's press will be addressed by the President, the Lord Mayor of this city, His Worship Senior Counsel Elias Lukwago. I believe you're ready.
First of all, I would like to salute you all, the National Chairman, our Commander Mobilization, and the entire. And the third issue is about the progress regarding registration of PFF. Those are the three issues we are going to canvass at this press conference. The first issue is segmented into two because this morning we have registered victory at High Court. Yes, a well-deserved victory because it's been a long haul for our colleagues, the famous Kisumu 36, who have been suffering under the yoke of those trumped-up charges of terrorism right from the time they were kidnapped from Kisumu. Way back in July last year, they have been battling those charges till this morning of the 5th of May, when finally they have been discharged by court. Some good news, of course. As we always say, it's not yet Uhuru, but at least when you register mileage in any given struggle, there is every reason to celebrate it. We are not overly excited over the same, but definitely it is some good news that brings some temporary reprieve, which we must acknowledge. And indeed, we congratulate you, comrades. So before I proceed to highlight the other issues relating to that aspect of justice and human rights, permit me give this slot to one of the Kisumu 36 to recount the trials and tribulations, what they have gone through and what it means to get discharged this morning. We'll just have a few minutes. You hear it from the horse's mouth. I think it's only fitting that never surrender. Never surrender. Never surrender. Never surrender.
Thank you.
Let's rise up and honor this victory. Honor our colleagues. We shall overcome. We shall overcome. We shall overcome someday. Deep in my heart, I do believe we shall overcome someday. Besigye will be free. Besigye will be free. Besigye will be free someday. Deep in my heart, I do believe Besigye will be free someday. Thank you. Thank you. Thank you, thank you, thank you. As I told you, this aspect is multifaceted. This issue of human rights and justice. That is one component of the package of this multifaceted theme of human rights and justice. But to build on that, of course, we want to applaud Justice Susan Okalani for setting this record. It is unprecedented. One unique case you will read about in the history of Uganda is the case of the Kisumu 36. Because there are new precedents that were set. This is one being of them. Because hitherto, no case had attracted a decision of that nature where a condition is set that should the state fail to gather evidence and prepare committal papers within 6 months, the accused persons will stand discharged. What normally happens, the state fails to commit you within 6 months, then you get, well, what they call mandatory bail, but still they keep harassing you, and the conditions are set even for the mandatory bail. But in this particular case, the judge said if they fail to gather the required evidence, assemble and prepare the record of procedure, the committal papers within 6 months, they will stop reporting, and the matter will end there. This brings me to the second segment, that with this development now, the charge sheet against Dr. Besigye remains hollow. It's hollow in a sense that the particulars of that one count, because it is treason, they highlighted the number of particulars of the count. The key one is the alleged commissioning of the 36 to go to Kisumu for training in terrorism. That is the key ingredient, key aspect of that particular count of treason preferred against Dr. Besigye. Now that this one has collapsed, they have failed to gather evidence. So it means, therefore, that the case against Besigye is standing on a very shaky ground. The very reason we demand that they should do what naturally should be done under the circumstances, to have the charges against Dr. Besigye withdrawn and discharged. That's what they should be doing with this new development now, where the case against Kisumu 36 has crumbled on that account of the state failing to gather the necessary evidence. Of course, the evidence has always not been there. These are trumped up charges, holding charges, which are intended to persecute political dissent. The other aspect, again, related to that is the demand we are making that the judiciary should expeditiously fix the hearing of Dr. Besigye's bail application. We filed it, as we notified you, on the 17th of April. Today is the 5th May. Yes, subsequent to the filing, it was allocated to Justice Baguma. But since then, our teams have been walking up and down the corridors of court without making any headway as far as fixing the bail application is concerned. Now, we are at a loss as to what is going to happen next, because the judiciary is tight-lipped on this. Justice Baguma, with all due respect, we ask that you check in your diary, find an appropriate date, and we pray it should be, because Dr. Besigye has been on remand for a very long time together with Obedi Lutale. We keep reminding you they were kidnapped on 16th of November last year, and up to the present moment, no iota of evidence has been assembled against them. So we ask the judiciary, bail is a right which can be granted. Of course, it may be discretional, but one has got a right to be admitted to bail no matter the gravity of the offenses or the offense for that matter. So we demand the judiciary should expeditiously fix that case. In the same vein, for once, we would like also to applaud Wangadia, the Uganda Human Rights Commission, for once. Of course, she has always behaved in a very funny way, in the way she has managed the commission, totally oblivious of her mandate under the Constitution. Yes, it may be too late, but we have every reason to say, okay, thank you for waking up. Yes, you may take long to wake up, but when you wake up, at least, and do the right thing, probably it's only deserving that we say kudos. But we hasten to add a caveat to that. Under Article 53, you may wish to understand the full import of this provision. It's very, very important. Under Article 53, which clothes the Commission with the mandate to issue such orders, power of the Commission. In the performance of its functions, the Commission shall have the powers of a court. The Commission shall have powers of a court. A, to issue summons or other orders requiring the attendance of any person before the Commission and the production of any document or record relevant to any investigation by the Commission. B, to question any person in respect of any subject matter under investigation before the Commission. C, to require any person to disclose any information within his or her knowledge relevant to any investigation by the Commission. And D, to commit persons to contempt of its orders. That is Article 53, Clause 1. Clause 2, the Commission may, if satisfied that there has been an infringement of a human right, freedom, order, A, the release of a detained or restricted person, B, payment of compensation, and C, any other legal remedy or redress. Now, the Commission has taken one step for which we commend them. They have issued an order of release of Sebufu Edward, aka Eddie Mutwe, and of course others, because he was not picked alone, he was not kidnapped alone. There's Kunta Kinte, you know him very well, and another person. But now, our demand is twofold. Number one, this order should extend to all political prisoners who are incarcerated illegally. The order should be comprehensive. There are so many people hitherto being persecuted before the General Court Martial, and I'm using it deliberately, that term persecution deliberately, because they are not being prosecuted before the General Court Martial. We went to the Supreme Court. We won on the 31st of January, and the court unequivocally stated, please, that kangaroo court is dismantled. And therefore, if you have any pending charges against them, please transfer them to the ordinary civilian courts. To date, many political prisoners are still languishing in Chitalia. They are in Luzira, many are in other detention centers without any trace, without being tried in civilian courts, in total disregard or violation of the Supreme Court order and the Constitution. So it's incumbent upon Justice Wangadia and her team at the Commission to invoke the same provision, extend this order to cover all political prisoners. We demand that. That is number one. Two, I have read this, the power of the Commission.
In the performance of its function, the Commission shall have the powers of a court and to commit a person for contempt of its orders. We demand now that Muhoozi Kainerugaba has defied flagrantly, obdurately, stubbornly, recalcitrantly this particular order, that he be summoned, be arrested, and held in contempt. That should be done immediately. If Justice Wangadi and her team are to be taken serious, that actually they meant what they said, and they believed in the orders they issued, and that the orders should be respected, and have a force of a court order. The order they issued has a force of court order under Article 53. If it is to be respected, and it is treated with the sanctity it deserves, then today, Justice Wangadia should issue a warrant of arrest against General Muhoozi for contempt of a court order. I call it a court order because that's what the Constitution says, that it has a force of a court order. It is equivalent to a court order. Otherwise, if this does not happen, then it will be treated as a mockery. Actually, the Commission will be subjected to ridicule, which will be irreparable. Already it has been suffering a crisis of confidence, a credibility crisis, and it is just struggling to regain its image. So we demand that if they meant well, if indeed they meant that actually they were serious, they should cause the arrest and prosecution of General Muhoozi. What happened to Aaron Kizza? He was arrested for contempt of a general court martial. Aaron Kizza, you remember the way he was picked? For him, was not even given the luxury, the latitude of getting summons, warnings. Because for the case of Muhoozi, they said, please release, or else you may be held in contempt. For the case of Aaron Kizza, it never happened. First military men there just pounced on him, hounded him, dragged him around, tortured him, and eventually he was taken to Chitaria, where he spent months on account of contempt. Muhoozi may not be subjected to the same humiliation, but a warrant of arrest should be issued if we are to take this serious. The other thing about human rights, again, the continued persecution, the issues of justice and human rights, the continued kidnaps, which are going on unabated. These are crimes against humanity. I'm glad, and we're reporting to you, under the leadership of our senior counsel, Martha Karua, we have resolved to take this matter to the ICC. Doesn't that deserve a clap? I want to assure you, we have assembled a team to deal with these matters, because they are not only here in Uganda, they are all over. In Tanzania, Tindi Lissu, you know what is happening to him? Even after kidnap, he was picked from prison and taken to somewhere where he could not even be accessed. Held incommunicado, leader of opposition. Yes, Kabila may have committed atrocities, but he's facing the same treatment in DRC. Riek Machar, you are aware what is happening to him. He's been under house arrest for a very long time. And in Kenya, day in, day out, abductions are happening. Now they have extended it to broad day shooting. A member of parliament was shot in broad daylight. So we are all an endangered species. We are all in harm's way. So we are saying, yes, at East Africa level, we team up and take this matter to ICC for redress. We are also doing the same at a regional level, because we had informed to you that we are networking with a number of NGOs and human rights organizations which are involved in public interest litigation in Kenya and also at East African Court of Justice. So Martha Karua was here the day Dr. Besigye was brought back to court, and we have taken a decision. Very soon we are going to proceed in that direction. That is issue number one. Number two, it's about the ongoing display exercise, voter verification exercise. You are aware this is a part of the, a series of activities undertaken by the Commission ahead of the 2026 elections, and their roadmap, the calendar, they rolled out a number of activities written. They started the display on the 25th of April, and they said it's ending on 15th in May. What is our position now? As PFF, we demand that this exercise be suspended. It's our demand. The Electoral Commission should call it off. Why? It has turned out to be a farce. It has turned out to be a total flop. There are a number of reasons we are advancing here. Number one, it has been a flop. It's a farce. You can all bear testimony to this. Everywhere they are claiming that there is display going on. It's just circus. Circus, nothing else. You've heard the testimonies of their own officers that on a given day, at any given center, they may receive like a 2, 3, 1, or nobody at all coming to do the verification. And this is the issue which claims they have 20 million voters on the voters register. So if you do the tallying, you would find that if we were to get statistics from the EC, by now they will tell you not even a quarter of the registered voters has been verified. So it has been a total flop. They never prepared for it. They didn't have sufficient information to the people. They never in any way attempted to do the nitty-gritty, the prerequisite for the exercise to be successful. But that aside, the most serious ground is that key stakeholders in this exercise, those are the political parties, have no space to participate in this exercise. The key stakeholders, you appreciate under the law, particularly under Article 59, I'll read you Article 59. Every citizen of Uganda of 18 years of age or above has a right to vote. It is the duty of every citizen of Uganda of 18 years of age or above to register as a voter for public elections and referenda. 3, the state shall take all necessary steps to ensure that all citizens qualified to vote register and exercise their right to vote, and so on and so forth. Now, political parties are in disarray because of the state-orchestrated mayhem going on in the country. For us as PFF, we would be mobilizing right now the people to participate in this exercise. But you can see, left, right, center, we are in battle. We are battling to get Dr. Kizza Besigye out of jail together with Obed Lutale and a score of other political prisoners. So we can't spread ourselves thin. Everywhere you go, actually, even if you ask people to participate in the exercise, they will ask you, the question they pose, what is happening to Dr. Kizza Besigye? Shall we even have elections under those circumstances? Those doubts are lingering on the minds of many Ugandans, considering what is happening to Dr. Besigye and others. Now, as we were struggling to get Dr. Kizza Besigye and other political prisoners either to being held under the General Court Martial to trumped up charges, then they descend on others. We have just mentioned Eddie Mutwe here and others, where Muthoza has even the audacity of bragging that is having Eddie Mutwe under his basement, teaching him Runyankore. Those are statements which are very serious. They go to the root of the Constitution. Actually, they rendered the provisions of this Constitution illusory. Totally useless, that this Constitution is just a mere paper tiger. So how do you, under those circumstances, how do you convince people to go and register? In fact, where do you even get the guts? We are on a hunting spree, hunting from one prison, from one detention facility to another, looking for political prisoners, people who are disappeared by the state. People who are victims of enforced disappearance. So the political parties are involved in that. For us here, as we assembled here, all our minds are on how to get Dr. Besigye and others out of prison. When the new people also assemble at Kavure, is how to look for their loved ones, for their members who have been kidnapped and held incommunicado in ungazetted detention centers. And many of these other political parties, that's what is happening. So, who is mobilizing people to participate in the voter verification exercise? And how can the commission just continue like this? They have not even called for a meeting. By the way, they are ostracizing us. The commission has got an obligation even to visit political parties, because these are registered political parties. In my life, I've never seen here Justice Yabakama Katonga. Or even those days, Najana Nkumbi. I don't know when he visited in Najana Nkumbi. I've never seen him visit Kavure. I've not seen him visit, maybe they can always hobonobo with Mawa, I don't know. But yes, that one I cannot tell. But at least you can all bear testimony to this fact that Justice Yabakama treats us as criminals, as enemies of the state. So we are dealing with a criminal state, and we are being ostracized. So how do we participate in the voter verification exercise under those circumstances? So the Constitution has been abrogated, and therefore it becomes extremely difficult. Look at this particular provision. Very interesting. You know what happens when recommendations are made to flag out the names from the register? When they are flagging out the names from the register, the recommendations go to the returning officer. And once they go to the returning officer, under Section 26 of the EC Act, the next stage would be to establish the parish tribunals. Who has the mandate? At least when I was Shadow Attorney General, we moved an amendment. In those days, it would be the LC2 to constitute themselves into election tribunal.
Era njagala okwebaza mwenna abazze wano olunaku olwaleero, mwebale nnyo, mwebalire ddala nga wabategeezezza ku Mande koonako ali eri ku geeti anaabatayambadde ajja kuyingira. Nsonyiwa mpulire ndabye maama wange ng'aseka, nja mmuteerawo mulala. Anaabatayambadde kala yaffe ya bbulu.